Good morning. The crucial points was devaluation of property left by the deceased when there was no will. How to calculate the share is time to time a question to be discussed deeply, learned and educated. So yet another case AAR 2025 Madhya Pradesh 118. AAR 2025 Madhya Pradesh 118. Chandrabai versus Champabai and another. This case relate to specific relief act section 34 because there was a declaration, and then section 10, 15 and 6 of the Hindu Succession Act 1956 as well as after amendment 2000. Then there was also discussed about adverse possession, article 65 and 64. Therefore they say the adverse possession not available to defendant because it is joint family property. So the question is, lower court decreed the suit by allotting half share to the plaintiff and half share to the defendant, only left out daughters by deceased father. Then question arises, the defendant claim was he is having a share over his mother. Therefore he wants that because the first wife died predeceased, second wife died after death of, therefore at the time of death of the father, the second wife will have a share and the two daughters will have each share, first wife daughter, second wife daughter. Therefore this was the combination of issues before the lower court. The lower court has granted half share each. Then question arises, appellate court has set aside the judgment and they have also passed 2/3 to the second defendant and 1/3 to the first plaintiff and directed for final degree. Therefore another application was filed, cross objection, when second appeal was filed before the Madhya Pradesh High Court. The Madhya Pradesh High Court, after setting aside the appellate court judgment and upholding the lower court judgment, allotting half share each to the two daughters, ignoring the claim of the defendant that he will have another share from his mother. Then the judgment discussed about Supreme Court judgment AAR 2006 Supreme Court 33-32. All you must go to at paragraph 7, section 15, general succession in case of the female Hindus have been discussed. That was there. Then question arises, that was deeply discussed. You have to go through that. I cannot explain for want of time, and this telecast is for youngsters also, so seniors may go through it deeply. And the family tree was explained at paragraph 10, paragraph 13, family tree. So you must know how to draft family tree whenever you file suit for partition, even if any other religion, Muslim or Christian or Parsi or Sikh, family tree, writing a family tree is most important. So the section 6 amendment act is also having, and exhibit D23, a settlement deed was executed by mother to his daughter, was also ignored as not maintained. All these things you can go through the judgment. And finally the trial court is directed to pass final degree in pursuit of judgment passed by this honorable court. So you have to go through it and understand that in view of section 15, the property devolved by shall each, the surviving sons, daughters, and mother of the intestate shall take each one share. Thereafter, the distribution of share about problem was the share will reverse back under section 15 of the Hindu Succession Act. They say any property inherited by female Hindu from her father or mother shall devolve in the absence of sons, not upon the other heirs referred so and so. Then they say if it a female Hindu inheriting from her husband in absence of any son or daughter of the deceased, including the children of any predeceased, not upon the other heirs referred, but upon the heirs of the husband. This is 15 class 2b. All these things has been discussed, and finally share was allotted to each half share each daughters. Go through the judgment.